When it comes to the topic of estate planning, it can get complicated and confusing. So, we would like to keep it simple. Basics of how estate planning works. Let's begin with you, or the both of you if you are married. All of us have an estate because many of us own real property, like your home or other real estate. We also own personal property, like automobiles, clothes, furniture, jewelry, TVs, computers, etc. And we also have title property, like bank and brokerage accounts, stocks, bonds, mutual funds, life insurance, retirement plans, and other financial entities, like a business that could be a corporation, LLC, etc. All of these make up your assets. We all have heirs, or beneficiaries. Typically, these are your children, those who you want to receive your assets after you pass. This could also be a charity like your church. The objective of an estate plan, then, after your passing, is to make sure the assets go to the beneficiaries. Pretty simple. However, there are sometimes conditions. One definition is a condition can be a future uncertain event. And if the event happens, something needs to be done. As an example, if one of these beneficiaries were only 12 years old, he would be unable to receive your assets until he reached a certain age, usually 18 or above. Therefore, a provision would need to be made to allow for this. Conditions may have a major impact on the total estate planning process, as they can affect your beneficiaries, as we have seen. Additionally, a beneficiary could be from a blended family. This means without proper consideration, he may be inadvertently disinherited. A beneficiary may have special needs. This means he may have a physical or mental condition and be currently on government benefits. The beneficiary may be a spendthrift, one unable to handle money, or the beneficiary may have other personal issues like substance abuse. Conditions apply to assets in the manner of how an asset is structured. As an example, property can be titled as joint tenancy with right of survivorship, or titled in only one person's name, or an asset can transfer directly to a beneficiary. These multiple conditions make it difficult to have an efficiency of transfer. And if you don't do anything about how your assets are structured, when you pass, state law usually requires that all this be handled through court proceedings. This process can take many months. Because probate is time-consuming, expensive, and unnecessary, smart people plan in advance to avoid placing this burden on their heirs. Finally, conditions can apply to you. As an example, you could become incapacitated. The question then is, what is the best way to make sure you get all your assets to your beneficiaries and take into consideration all potential conditions? When you do the research, you find that for most people, the best option is the revocable living trust. Let's see why this is so and how the revocable living trust works. When you initiate a revocable trust, you become the creator. This means you set up the trust and you say how your assets transfer, when they transfer, and who will get your assets. Next, you are the trustee. This means that you hold title to the assets that are in your trust. This is why you transfer all your assets into your trust: your real property, your personal property, and your title property. Additionally, you are the beneficiary. This simply means you continue to use and enjoy all your assets. Also, you need to select a successor trustee. This is one who will implement your instructions if you become incapacitated or when you die. Normally, adult children are chosen for this position. One more point. You can also select a corporate trustee. When one of you dies, typically there is nothing that needs to be done. However, in some cases, the trust assets may be divided into some trust. Normally, we call one the A trust. The survivor's assets go into the A trust. The assets of the person who dies go into the B trust. The B trust is a holding trust, as it holds assets for the benefit of the surviving spouse. Typically, the B trust can provide income for the benefit of the surviving spouse, and principal can be taken from the B trust for specific reasons. Reasons one would divide the trust when the first person dies are state and federal estate taxes. At this time, the federal estate tax is 40% on the asset values that exceed the federal estate tax exemption. This is currently slightly over $5.4 million. So, if your total estate is valued at $6 million, by dividing trust assets, you would eliminate having to pay the estate tax. About a third of the states have state estate taxes, with taxable percentages that go as high as 20% and exemption amounts that begin as low as $675,000 and increase to match the federal estate tax exemption. A second reason to divide trust assets would be subsequent marriages. For couples in a subsequent marriage, it is appropriate to divide assets to protect the beneficiaries of each spouse, thus assuring these individuals receive their fair share of the estate. When the surviving spouse dies, the successor trustee takes over and follows the trust instructions to distribute the assets to the beneficiaries. However, if there is a condition, such as the beneficiaries are still minors, the trustee will hold the assets in a holding trust and pay out income from the trust and principal for certain conditions such as college education. The ability to hold trust assets is how a trust can handle a future condition that would apply to a beneficiary. Let's take a look at some other conditions that could apply to you and what documents usually are used. The first is distribution issues. We have already seen that the Revocable Living Trust has the capacity to handle multiple conditions that might arise in the distribution process. The next is incapacitation. Durable powers of attorney are designed to select a person to act on your behalf to make decisions if you become incapacitated. There are two durable powers of attorney. One is designed to select a person to make financial decisions if you cannot. The other allows a person to make medical decisions if you are incapacitated. The next is a living will and advance directives that can be used to state your wishes about being kept on life support systems. And if you forget or do not transfer an asset into your trust, there is a last will, sometimes called a pour-over will. This will directs any asset that you may individually own to go to your trust. This allows for all your assets to be distributed to your beneficiaries the way you want. Assets that flow from the will to your trust may be subject to probate. This is why it's important to transfer all your assets into your trust. When we set up an estate plan, we provide you a secure, password-protected account in the cloud, your client counsel. This account is complimentary for 90 days and provides a number of benefits like e-sign dynamics. This means you can sign all your documents online using this e-sign technology. 24/7 document access means you can access all your personal documents at any time in the cloud. And free document changes means you can make changes to your documents at no additional charges. Your client counsel also provides a funding cap where all your assets can be transferred into your trust. These are the components you should have in your personal estate plan. We call this the estate plan portfolio. What's next? Contact the person who sent you to this information. They can help you. They can give you a price quote, and they will help you complete the process.